Welcome to today's video. Today we will discuss how to draft your combined summons for a divorce in the High Court. Firstly, any divorce has to take place with a summons. Some people are of the view that you may go to a court and ask the court to divorce you. That's not how it works. You have to draft a divorce summons, in this case a combined summons, and you will have to have it issued at court, served on the other side, and if they do not oppose it or defend it, you would need to set it down for hearing, where one of the parties would have to testify and convince the court that the marriage has broken down. That is the long and short of a divorce. But today's topic on how to draft it. First, you will have to do is draft the summons. And the reason why they call it a combined summons is, you will see later on, a particulars of claim is also attached to it. This combined summons is issued out of the Western Cape High Court. You will see there's a case number, the name of the parties, in this case Kate Wellington, the plaintiff. She is instituting the divorce proceedings, and her husband Tom Wellington, the defendant. Hopefully he will not be defending it, but he is the other side to this specific divorce. You instruct the sheriff to serve this combined summons on Tom Wellington. These are his details. And the sheriff will inform him that Kate Wellington is seeking a decree of divorce against him. And the reasons, therefore, are outlined in the consent paper. My apologies, in the particulars of claim. Later on, we will provide with a draft consent paper. Furthermore, the sheriff would inform the defendant that if he decides to defend this action, this divorce, he has 10 days to do so, and also how to do it. And after he notified the plaintiff that he intends to defend the divorce, he has 20 days to file his plea. His plea is basically his reasons for not wanting a divorce. Alternatively, his responses to the particulars of claim. The sheriff would further inform the defendant that if he fails to do so, the divorce may proceed undefended, and furthermore, that the matter may be set down without notifying him if the matter is undefended. And of course, the sheriff would file this document, they call it a return of service, with the court. What they usually do is they give it to the plaintiff's legal representative. You would see further below, the registrar of the High Court would sign this summons. In this specific case, Kate Wellington is representing herself, and therefore she will provide these details. She's in person, her address, her email address, and a telephone number. And this document would obviously be sent to the registrar of the High Court, Western Cape, the Office of the Family Advocate if there are minor children involved, and of course, most importantly, to Tom Wellington, because he is a defendant in this divorce action. The particulars of claim. This document is combined with the summons that you have just seen. In this document, we say who the parties are first. The plaintiff and the defendant are as described on the face of the summons. We early on shown you who the plaintiff is and who the defendant is. And you further say that the defendant and plaintiff are domiciled within the area of jurisdiction of this honourable court. This court, the Western Cape High Court, cannot divorce a party if at least one of the parties are domiciled or resident within the Western Cape. That's very important. And thirdly, we now outline the facts of the matter. On the 21st of February 2020 at Durbanville, Western Cape, the parties got married to each other in community of property and profit or loss, and they're still so married. You cannot divorce a couple that is already divorced or who are not married. And we attach to this document a marriage certificate. Here is our example of a marriage certificate. The court would obviously want to see that the parties are married. In this example, there are no minor children born from the marriage. And the court will not divorce parties who are happily married. Therefore, Kate or the plaintiff will state the following. Plaintiff avers that by virtue of the following facts and circumstances, the marriage relationship between the parties has broken down irretrievably, and that there is no reasonable prospect for the restoration thereof, in that no love and affection and no longer wish to be married to the defendant. Wherefore, plaintiff prays for, now this is what she asks for from the court, a decree of divorce, and the terms of the consent paper entered into between the parties attached here to be made an order of court. So in this specific situation, Kate and Tom entered into a consent paper. Here is a consent paper. I shall deal with it in short in a moment. And then cost only in the event this action is defended. It's possible that Tom may say, you know what, I no longer want this consent paper, I'm defending this divorce, which could be problematic because he entered into a consent paper, and further an alternative relief. And then again, Kate signs this document. It's sent to the High Court, the Office of the Family Advocate if there are minor children involved, and of course to Tom. Now let's deal with the consent paper. This is a blank consent paper, but usually in the consent paper, you will stipulate that neither party would be claiming support from the other. If there are properties involved, it will deal with how to divide the joint estate, or it might state that Tom may keep this house and Kate may keep that house. If there's a pension fund involved, it might stipulate that the pension fund should pay half the pension interest to Tom and vice versa to Kate. If there are cars, it might stipulate that Tom keeps his car and Kate keeps her car, and whatever other important aspects there are regarding the joint estate. This document, as mentioned early on, in its totality would be served on Tom, and if Tom decides not to defend the matter, as mentioned earlier on, Kate can approach the court for a date and the matter would be finalized unopposed, and hopefully the consent paper will be made an order of the court. I hope that was of some assistance, and if you do decide to get divorced and deal with the divorce on your own, we advise that you make sure that you double check with the court before issuing the summons or the documentation that's applicable to the divorce, that the documents are in order and that there will not be any problems afterwards. Best of luck.